Okay, everyone. Good morning. Thank you for attending this webinar. My name is Paul McDonald, and I am the Vice President of Education for AI, also an architect here in Buffalo and Director of Facilities for the Buffalo Public Schools. And I want to welcome you to our webinar today, which is Protecting Your Practice, Projects, and People in These Uncertain Times. The session will run for about 60 minutes with answers at the end. The program is being brought to you by the 14 New York region chapters of the American Institute of Architects, and the session is approved for one learning unit. They'll be applied to necessary for membership in the EIA. In order to earn the credit, you must be present for the entirety of the session. Throughout the program, you will see 4 words appear in the chat box at various times. Take note of these words as you see them. You will be required to write them on your CE card. They'll be provided in the chat at the conclusion of the program. This card must be filled out and returned to us no later than this evening at midnight. The card is digital with instructions. You do have the ability to control the size and placement of the video of our presenters and may toggle back and forth between the two throughout the webinar. Questions and participation throughout the session are encouraged. Content question for the presenters, use the Q&A box at the bottom of your screen. If you're having any technical issues or have a question about the webinar itself, use the chat icon at the bottom of your screen. Please note, the information webinar is not intended to constitute legal advice. Instead, all the information and materials available during the webinar are for general informational purpose only. And at this time, it's my pleasure to introduce speakers. David Kossakoff, who is a partner with Sinright, Kossakoff, and Messina. Haley Dreyer, who is a partner with Cullen and Dykam. And Thomas Wassel, who is a partner with Cullen and Dykam. I'd like to turn it over to our panel. Thank you.
Thank you very much, and good morning to all of you, and thank you for participating in today's program. We're overwhelmed with the response. As of right now, we have almost 200. We're grateful to the AIA and its members for the opportunity to address these issues which are relevant to your practice in this unprecedented time. And we trust that you are all well and doing the best you can to cope with the circumstances we're all facing, and we recognize that if you're on this call, you are looking to navigate the tenuous role of maintaining your practice during this period of relative uncertainty. It's our hope that we can give helpful information that may provide you with some guidance and assistance. Let me start with brief introductions of today's panel, and then we'll get right to the main theme of our presentation. As Paul indicated, my name is Dave Kossakoff from Sinright, Kossakoff, and Messina. For more than 30 years, I've devoted my practice to the representation of design professionals, working with architects, engineers, and land surveyors, defending lawsuits directly or through your insurance carriers, as one of the leaders in architects. I've handled trials and arbitrations throughout New York and New Jersey, and I also serve as an arbitrator and mediator. I also negotiate and draft matters before the Office of Professional Discipline. And for nearly 20 years, I've had the honor of serving as the General Counsel Westchester Hudson Valley chapter of the AIA. A quick shout to Valerie Brown and the executive board of my chapter, who first conceived of this presentation and soon reached out to the AIA New York State. Your AIA representatives from the state embraced this program and mobilized at lightning speed to get this program up and running as quickly as they could. Georgie M. Bailey and her staff should be commended for their efforts to educate their members and address this topic. And we have limited time through the subject matter and leave time at the end for your questions. Importantly, I am smart enough to know what I don't know. Accordingly, I sought out industry specialists in fields appropriate to the operation of businesses. I called upon Tom Wassell and Haley Dreyer, both whom are partners with the law firm of Cullen and Dykman. Cullen and Dykman is a diverse firm of more than 150 lawyers practicing in a variety of specialties throughout New York State. We will be relying on Tom and Haley to provide valuable insights into employment practices and to issues of relevance to today's world. I have to tell you that Given the fluid state of affairs, this presentation continued to evolve on a daily and hourly basis. This is a function of the ever-changing requirements imposed by the governor of New York State in response to the evolving status of the epidemic, and to the newly adopted, or nearly adopted, hopefully, multi-trillion-dollar stimulus package, which as of this morning is awaiting approval by the House of Representatives. So I will proceed. As you can see on your screen, that's our good-looking panel that you'll be dealing with today. And moving along to the next slide, I will start off by addressing risk factors for small, medium, and large firms. Whether you are part of a small, medium, or large firm, the impacts affect all of you. Although candidly, those impacts are not necessarily felt in the same way. Like many of you, I too am a business owner. It's not hard to conceive that my bills will not be given priority by many of my clients. When people are uncertain about their financial wherewithal, they become skittish about writing checks to what they might consider to be non-essential functions. Many of my clients run to me in the worst of times looking for counsel. However, given the choice between paying their lawyer or paying their grocer for food to put on their table, I would have to imagine that the food bill gets paid first. The utility companies, the pharmacist, internet company, the gas station attendant, the insurance provider, and other more vital functions will undoubtedly be prioritized. The domino effect is that my bills sit on the low priority pile until the dust settles, if the dust settles. Many of you who are solo practitioners or run small firms and cannot afford to pay their bills if their bills are not paid may experience similar issues that I will. Depending on your practice, you may find yourself in a situation where you have difficulty maintaining your payroll or meeting your other costs. I've discussed these issues with several architectural clients, some of whom I note are on this call, and they also tell me that some of their bills are not getting paid. Some of you have reported that the projects that you expected to be approved with outstanding proposals have stalled, meaning that work that you thought was coming in the door is no longer available. In discussions with your colleagues, I find that cash flow and the flow of work is very much determined by the type of practice you are engaged in. And just as an example, in my practice, a fair amount of our work deals with municipalities, or we work through insurance companies representing architects. And thus, at least some of my income remains in the pipeline and provides me with some optimism that money will come in the door. However, we handle a lot of litigation, and since the courts have substantially cut back work we would ordinarily be doing, attending court conferences, trying cases, doing depositions, has been significantly reduced. Now, I have gone through great lengths over the years to manage my overhead and minimize my expenses whenever possible. I don't suggest that I am the paragon of sound office management, but we have attempted to be thoughtful about unnecessary expenses. Of course, I still have personnel, which is my biggest expense and probably the biggest expense of many of you. But I did choose a location for my office that allows me to pay a lower rent, one of the typically largest expenditures of any business. I think that for those of you who come out of the other side, and optimistically, I think that that will be the overwhelming majority of you, this crisis may cause you to evaluate the way you run your business. Keep expenses to a minimum whenever possible. For those of you who have personal expenses that require a steady stream of income, you have options. Putting aside the availability of funds from the newly adopted federal stimulus legislation, since it remains to be seen how user-friendly it will be or who will be eligible, finding other ways to defer costs should be at the top of your list. Consulting with landlords to negotiate a deferral of rent in these times is not unusual. In fact, there is proposed legislation to defer rent obligations for a period of time to minimize the financial burdens to tenants. There are corresponding proposals to delay required mortgage payments by landlords so that they are not saddled with the brunt of the financial impact of the lack of rent payments. In addition, the court system has scaled back considerably, as I mentioned. The courts are essentially overseeing the most critical cases involving life and liberty and do not regard eviction proceedings as a priority during these difficult times. Accordingly, landlords lack any real leverage to make good on threats to evict you from your homes or offices. Absent unusual circumstances, no judge is going to put you out on the street in these present times. In fact, they would rather find a home for everyone rather than overpopulate the streets and violate social distancing requirements. Even in the absence of legislative mandates, those of you who have mortgages may find similar relief. Many banks are sensitive to your dilemma and are willing to work with you and permit a forbearance of payments for up to 90 days while your cash flow is compromised. You can simply call the institution holding your mortgage and ask. To be perfectly honest, they are expecting your call. By exploring these options, for those of you who find yourself in dire financial straits, this may allow you to stem the tide while you're navigating where your next paycheck is coming from. Some of you may be so close to being tapped out that you may be considering layoffs if you haven't done so already. In the absence of work coming in the door, this may be a necessity. You can consider changing the status of your employees to independent contractors. You may furlough employees during these tough economic times. You may decide to terminate some employees. In some ways, the survival of your firm may necessitate these actions. By pursuing these options, your staff may be eligible for unemployment insurance, even partial benefits, if you reduce hours. Some of my clients are considering percentage reductions in salary across the board to remain afloat. Any of these options require more investigation, but can be considered. But I have to caution you, before taking such actions, we encourage you to fully digest the terms of the new federal legislation to see whether you may compromise options for financing. I'll address that in a moment. In terms of continued operations, my attorneys and staff are operating remotely, and I suspect that many of you have the wherewithal to do that as well. Generate documents, participate in conference calls, such as this, and provide representation when needed. I will also tell you that my partner is on the zoning board of a local municipality, and just the other day, they held a public work session by the use of the Zoom platform to issue approvals for pending projects. In terms of insurance, an important consideration is to make sure that you maintain your professional liability insurance intact. In uncertain economic times, history has demonstrated that conflicts are not uncommon. As design professionals in New York State, I'm sorry to say that you have personal exposure for negligent acts. It is the primary reason why sufficient coverage is essential to your practice. By allowing your coverage to lapse, you may create a level of exposure that could be financially devastating. I would suggest that you don't flirt with disaster. Another question that I get asked often is whether claims for business interruption and lost income are covered under your business coverage. I will give you a typical and never popular lawyer response. It depends. It depends on the language of your policy. Although generally I would say that it's an uphill battle, I would also tell you that in some instances, recovery for losses, it typically is subject to a waiting period. Some policies include language that losses may apply to an order of a civil authority, which arguably we have those requirements here given the executive orders issued by the governor. However, it generally also requires physical harm, which closing your office may not qualify for. Believe it or not, many policies also include exclusions for viruses and microorganism attacks. Carriers have already denied claims, and one can expect that such claims will ultimately wind up in court without a resolution for years to come. Bottom line is that if coverage is available, it may take years to put dollars in your hands after the insurance industry battles mightily to avoid paying such claims. There are jurisdictions, I don't believe New York is one at this time, I believe New Jersey may be, that are trying to impose a requirement upon insurers to provide retroactive coverage due to COVID-19. Even if these proposed bills pass in the legislature, it's a short bet that the insurance industry will wage a battle that will last for an extended period of time. Moving along to the next slide, and dealing with existing projects. Let's face it, many clients are facing the same economic issues that you are. And so the flow of payment may not be, the spigot may have been shut off. You should be sensitive to contract terms that provide a level of protection for the timely production of documents or you providing your services. I took a look at the AIA general conditions for support. Time extensions for unanticipated issues are generally recognized. Understand that courts will bend over backwards to protect people who have been affected by this unprecedented event. In my view, it will be the exception rather than the rule that any court will consider any party in breach for the inability to perform due to delays related to the coronavirus. Check to see if your contract has notice requirements and procedures to protect yourself against claims. One thing that I have discovered in my many years of representing architects is that once a contract is signed, it's usually put in the bottom drawer, looks at it again until there's a problem. Then they call their lawyers and dust off the contract, and the lawyers look for language that best protects their clients. Be proactive in understanding your responsibility. Moving along to the next slide, communication with staff. Let's face it, these are difficult times. People react differently under difficult circumstances, but you could bet that your staff and your colleagues are worried. Whether they show it outwardly or not, they could always use some reassurance. For those of you who are leaders of your companies, during these trying times, effective leadership is essential. I'm called upon in my firm to provide leadership as well. If you hope to continue your practice or restart once the dust settles, the way you treat your staff is critical. And will have a lasting impact on how you are viewed and how you view them in the future. As a business owner, I am cognizant that the way I treat my employees during these difficult times can either alienate them and forever damage my relationships with them, or it can create a level of appreciation that will last for an extended period of time. It may buy me some loyalty if I, for lack of a better term, do the right thing. Look, let's face it, I mean, some businesses may not survive. I will say that I think almost all of you will. But, you know, this could create an opportunity for those of you that weather the storm to pick up projects from firms that don't make it. With loyal employees, you may thrive in the aftermath of this time period. Finally, before I turn it over to Tom and Haley to address their issues, I'd like to talk about building for the future. We can't exactly tell you what's going to happen with the legislation because currently it's 880 pages long and it was only distributed in its initial form Wednesday night. My suspicion is it will probably undergo additional changes before the House votes. A quick review suggests that small business loans may be available to small and medium-sized firms. One of the priorities that the legislature assumed was to minimize massive layoffs and the resulting impacts on unemployment benefits that go along with it. By feeding businesses money, the hope is that employers may maintain their workforce and keep people on their books rather than place them on the books of the unemployment line. If they can preserve jobs with incentives for employers, that can have a tremendous benefit to our society and our economy. It's for that reason that you really do have to look carefully at the legislation because some of the benefits of providing loans is that if you don't lay off people, those loans could be converted to grants. So there may be some significant economic benefits to not laying people off. So we don't have that information presently, because you can appreciate that reading 880 pages wasn't easy between Wednesday night and today. But be mindful of those issues as you move forward and before you take steps. But finally, building for the future. So you may find yourself with a little bit more time than you thought. You can consider opportunities for forward thinking about marketing and work when the dust settles. I thought about what I could do now to position myself in the future. There are marketing opportunities that I have been considering that I've put off for a long time. I've been looking to develop a portion of my practice that has been somewhat stagnant in need of attention. So I've already ramped up my efforts in these areas with the expectation that I can reinvent my practice to develop a whole area of practice that has really lied dormant. I'm hoping to come back stronger when the dust settles, and I believe that each of you can do so as well. So at this time, I'm going to turn it over to Tom and Haley, and they're going to speak to specific issues involving your practice for which that is their area of specialty. So Tom and Haley, take it away.
Thanks, Dave. This is Tom Wassell from Cullen and Dykeman. And as Dave described earlier, we have over 150, 180 attorneys these days throughout the state. I'm happy to address everyone this morning. In a little while, you'll be hearing from my partner, Haley Dreyer. Haley and I work together in this area, and we, I won't say we're experts, but we are as deeply immersed in this kind of stuff as anybody. For us, it feels like we've been involved in a lot of these issues for years. In point of fact, Governor Cuomo issued his first executive order declaring a state of emergency 2 weeks ago yesterday. And a lot of what you're going to hear about in the next 20 minutes or so is about executive orders and laws that have been passed or are about to be passed all within the last 2 weeks. It's just a dizzying speed of developments here. The governmental action that we'll be talking about is both federal and New York State as well. We've learned some new terms in this crisis. I think 20 years ago, very few of us had ever heard the term social distance, had ever heard the term hanging Chad, but that became part of the lexicon. Now the term social distancing has become part of the lexicon. We all know about that, and we're all practicing that. Probably all of you, like the three of us, are located in your home or perhaps alone in an office and not working with colleagues. It's been a sea change for all of us. The federal government has adopted, and we'll talk about it in a few minutes, mandatory paid sick leave under certain circumstances for certain employees. I hear a lot of misunderstanding about what the law is about, and we'll talk about it in a short time. Then, of course, the state of New York, as you're probably all aware, Governor Cuomo, he has a daily press conference, I believe, practically. He issued executive orders reducing the amount of people who were allowed to be on site at a business, first to 50%, then to 75%, or then to only 25%, and now 0%, to reduce on-site staff by 100%. We'll be talking about what that means and what it doesn't mean on the coming slides. So, and there is a special leave entitlement for people who are quarantined by a governmental order. So let's drill down to some of these nuts and bolts. What we intend to do is kind of a high-level overview of some of these issues. We're not going to be able to, in the time we have, drill down into lots of different specifics, but believe me, there are lots of specifics to consider. It's a highly fact-specific area. So the governor's executive order 202.8, which is the one that's currently in effect in terms of the workforce, has said that as of this past Sunday, 100% of the workforce must stay home, must work remotely, if at all possible. And This, of course, is to try and slow the spread of the coronavirus, COVID-19, or flatten the curve. Again, I won't bother with describing all of these terms. I'm sure you've all heard them. Now, there is an exception in Executive Order 202.8 for essential businesses. Now, in a moment, I'll talk about what an essential business is and maybe what it isn't. And also, if you are an entity that may not be considered essential yourself, but you provide services to an essential business, you are allowed to continue to provide those services, but again, only to the extent that you are providing services to such an essential business. So if you have a company, most of the people on this call, I assume, are architects, work in architectural firms, and you do work for the utility industry and you do work for a homeowner. As we'll discuss, work for the utility industry would be deemed essential. Work for the homeowner, not so much. So you can only provide the services necessary to service the essential businesses. Now, what are essential businesses? I do encourage you to take a look at the governor's executive order. And as you'll see at the bottom of this slide, there is guidance from the Empire State Development Corporation about what this executive order means and what essential businesses are. But here's a partial list, at least, of the essential businesses. And for those, I think for those on this call, some of the more important ones, or ones of most interest to you, might be essential infrastructure, manufacturing, and again, you'll see farther down, construction. Now, I've heard a lot of different opinions about construction. Is construction in general essential? Meaning, can all construction projects continue? And I think the answer to that pretty clearly is no. Some people are under a different impression. But if you take a look at that guidance document, that's the link that's at the bottom of that page, specifically item number 9, it says all non-essential construction must shut down except emergency construction necessary to protect the health and safety of occupants or protect the project if it would be unsafe to leave it at that point in time. Essential construction is things like roads, bridges, tunnels, utilities, hospitals, etc. So I have heard from some people in the construction field, oh, construction's essential, we can keep doing whatever we're doing. I am not convinced of that, and the guidance that is available from the state suggests that's not actually true. Again, Empire State Development has given certain types of guidance. You can stay open if you're servicing an essential business, but you cannot stay open to do everything that you might normally do. There is also a minor exception. If you're going to send somebody into the office once a day or once a week to pick up the mail, something of that nature, that's okay. But social distancing should be practiced, and really there shouldn't be more than one person in the office at a time, if at all possible. So at this point, I'm going to turn it over to Haley Dreyer for our next set of slides.
Sure. Thank you, Tom, and thank you all for joining us this morning. As we all know, the COVID-19 pandemic has dramatically impacted the way employers and businesses of all sizes operate today. Businesses are being forced to close, to lay off, to furlough employees, to reduce hours, and to shift employees to a remote work arrangement. At the same time, employers are being inundated with evolving federal, state, and local laws and regulations in response to COVID-19. They're literally being disseminated daily. Right before this call, Tom and I were talking that it seems like we've been talking about COVID-19 for years, but it's really only been, a week to 10 days. If you look back at the calendar, Governor Cuomo declared a state of emergency in New York on March 7th. COVID-19 was declared a pandemic on March 11th. The US declared a national emergency on March 13th. And by March 19th, nearly every state in the United States had declared a state of emergency. This week, New York City has confirmed, thousands and thousands of cases, making it the biggest epicenter of the outbreak. We're here today, as both Tom and Dave have said, to provide a little bit of guidance, high-level guidance on these issues. If you subscribe to Governor Cuomo's COVID-19 emails at night, he sends out a summary of the day's events regarding COVID-19, and he ends his email with a deep breath moment, a quote, deep breath moment, thanking those who really went above and beyond that day. For example, yesterday it was JetBlue. They're providing free flights to first responders who are coming into New York City from out of state. So this morning, we're all going to start with a deep breath. We're in this together. We'll get through this. We might suffer some pain, for the next few weeks or the next few months, but we are in this together and we'll get through it. So with that, going to the next slide, many of these mandates, these state and local and federal mandates, have caused employers to transition to telework. Many of you are home today. As a general matter, employers do not have to pay non-exempt employees who do not work. They do, however, have to pay exempt employees for any week in which they work. So by way of example, if Sally is an exempt employee who works 1 or 2 days out of the work week, Sally must be paid her weekly salary, even if she just works 1 or 2 days that week. To the extent, moving to the next slide, to the extent employers are considering or already have reduced their workforce due to the interruption of business operations and as a direct result or indirect result of quarantines, governmental shutdowns, and the general downturn in business, it's important for all employers to be aware of their obligations under federal and New York State WARN Act. The New York State WARN Act is more restrictive, so we'll review that one here today. It applies to employers with as few as 50 employees. So if you have 50 or more employees, listen closely. It requires 90 days advance notice of a mass layoff. And a mass layoff is defined as 25 employees or more if those employees constitute 1/3 of the workforce at a single site of employment. A mass layoff, and this may apply to some of you in the audience today, also is defined as a layoff that affects 250 or more employees, regardless of percentage at a single site, or a plant closing or relocation of operations resulting in a loss of employment for at least 25 full-time employees. The first definition, the first of these three, is really the most relevant here. The layoff of 25 or more employees if those employees constitute 1/3 of the workforce at a single site. In addition, and this is where many employers often get jammed up, if additional reductions occur in the future, all employment losses in a 90-day period count. So to the extent possible, you want to look at a calendar, you want to look at your budgets and plan for layoffs or reductions within the next 90 days, because that's how the Department of Labor will look at it. The analysis of whether the WARN notice is required is extremely dependent on the particular facts and circumstances of your case. As Tom noted, all of this is very fact specific. And the New York State Department of Labor has noted such with regard to the COVID-19 pandemic. In fact, there was recently a posting on the New York Department of Labor website that signaled an openness to consider pandemic-related layoffs as an exception to WARN, so perhaps not having to provide that 90-day notice. However, again, this is very fact-specific, and you want to consult your counsel with regard to whether or not you have to provide this notice. Moving to the next slide, so workforce reductions generally. As a result of the coronavirus pandemic, many employers, most employers, are being forced to make tough workforce decisions to deal with this significant economic impact and uncertainty. As an employer, you can reduce the workforce for any reason other than an impermissible reason. What is an impermissible reason? a discriminatory reason. So you cannot terminate someone based on his or her protected class, race, sex, national origin, etc. You don't have to provide a reason, but particularly with the economic issues going on today, that is certainly a good reason. We often counsel employers, Tom and I, that in order to minimize exposure, you often want to do a pro forma analysis, do a survey to make sure that the employees that are selected for layoff or furlough, that you classify them by gender, race, age to confirm that you're not selecting anyone on an impermissible basis. So we have a lot of different terms being thrown around right now. Layoff, furlough, reduction in force. We thought it might be helpful just to define these terms for all of you today. So a layoff generally refers to when an employer terminates an employee's employment without any right to be recalled or reinstated if business conditions improve. Laid off employees are entitled to a written termination notice, and that notice simply needs to state the date the exact employment ended and the exact date the benefits will end. Laid off employees are also entitled to a COBRA notice detailing, health insurance benefits that they may be able to continue on their if they pay for it themselves. With regard to layoffs, employers are obligated to pay out accrued but unused vacation time in accordance with stated policy. Severance pay is also not required by the law, but you want to look at your past practice to see what you've done. Employees will be entitled to collect unemployment insurance, and it used to be that there was a waiting period in New York, but Executive Order 202.5 recently waived that waiting period. So if you are laid off, you can immediately apply for unemployment insurance, which as of this morning was $504 per week. So what is a furlough? So there is no precise legal definition for a furlough, but it generally refers to a mandatory period of time off without pay. It is essentially an unpaid leave of absence that is initiated by the employer. And we typically see these during significant economic downturns or during seasonal business cycles. And the benefit to the employee is that employees typically remain eligible for benefits. It's not required, but health insurance coverage can be continued. You want to check with your individual plan to see if that is available. And there's sometimes an expectation of reinstatement. We caution employers, though, do not promise reinstatement. There can be a hope of reinstatement. And furloughed employees can generally receive unemployment. Again, you don't want to promise that either. That decision is up to the unemployment insurance division. It's not up to the employer. The benefit to the employer of a furlough is that, one, it reduces compensation costs, but potentially reduce hiring costs as well. If you're able to bring back the furloughed employees, you may not have to hire and retrain replacements. The one important thing we'll say about furloughs is that furloughed employees cannot perform any work or they are entitled to pay. So if an employee performs work while on furlough, the employer needs to pay the employee for the full week if he or she is an exempt employee. In this regard, we typically caution or advise employers to have the furloughed employees sign something acknowledging that any work requires prior approval, remove them from emails and any employer communications. And with that, I will turn it back over to Tom.
Okay, so another very popular, or maybe popular is the wrong word, but a very common topic that we're getting is about reduction in salaries. A lot of companies are doing that. I read this morning that a very large company is reducing salaries for something like 60 or 100,000 of its employees nationwide. In the state of New York, you can do this. You can reduce employee salaries or hourly rates, as the case may be. But New York does have a law that requires 7 days advance written notice before you do that. There's a law called the Wage Theft Prevention Act. Some of you may be familiar with that. You should have been, hopefully, giving to all employees at the time of hire this form that the state promulgates or something equivalent to it, which tells them what their rate of pay is, whether they're eligible for overtime, what their payday is, what the company name is, etc. It has to be signed by the employee and kept by the employer for 6 years. Well, you have to give a new Wage Theft Prevention Act notice to the employees 7 days ahead of time before you reduce their salary. Probably makes sense to do it to coincide with a payroll period. Now, for salaried exempt employees, and I think there was a question, just so it's clear, an exempt employee is somebody who is salaried, makes the minimum salary required by the state, which can range from anywhere to about $900 a week to $1,125 a week in New York City right now, 75 times the minimum wage, and they serve in an executive, administrative, or professional capacity. Those are exempt employees. Not everybody who's salaried is exempt, just so you know. That's a topic for a whole nother day. But if you're going to say to a salaried employee, we're going to cut your salary by 20%, and you say, okay, we're also going to cut your hours by 20%, that's inconsistent with an exempt employee. Exempt employees are expected to make their full salary whether they work 10 hours in a week or 60 hours in a week. So you can't tie it into the number of hours that they produce. You can reduce their salaries, however. Again, you must give 7 days written notice ahead of time. One other thing that most people don't know about, and I have to say I have never had personal involvement in this, but New York State has for a long time had a program called the Shared Work Program, which for employers who are trying to preserve their workforce, they need to cut costs in these uncertain and difficult times. Under the Shared Work Program, you can cut an employee's work days, not just the salary, but by 20 to 70%. And they'll work fewer hours, you will pay them less, and then they can collect partial unemployment benefits from the state of New York. If anybody's interested in that, you can go onto the New York State Department of Labor website and find more information at the link that's indicated below. I understand that the PowerPoint will be available to everyone or be made available to everyone at some point. I'm going to move on a little quickly because we're starting to run out of time. There's still a good deal of material to cover here. Recent enactments. Now, before COVID-19, there were a few different laws that we had to follow, laws or policies. There was the Family and Medical Leave Act, the FMLA. Many of you are probably familiar with it. Many of you have not had to be familiar with it if you have fewer than 50 employees, because it didn't apply to fewer than 50 employees. Welcome to the new Family and Medical Leave Act. There's also the New York State Paid Family Leave Act, which applies to every employer in the state, even if you have only one employee. And of course, every employer has its own personal or individual time off policies. Well, there are some new members of the family. First of all, the federal Families First Coronavirus Response Act, which is a bit of a tongue twister, the FFCRA. And also the New York Paid Family Leave Act in relation to the COVID-19 pandemic. And I'm gonna ask Haley to tell us a little bit about these statutes, or the first statute.
Sure, thanks, Tom. So we're gonna move a little bit quickly here because we are running a bit short on time. But high-level view is that the Families First Coronavirus Response Act, that is a bit of a tongue twister, so we'll call it the Families First Act, is the new federal legislation dealing with sick pay. Eligible employers are required to provide paid leave to employees. Who is an eligible employer? A business with fewer than 500 employees. Employers can receive benefits to be able to provide these funds to employees for the paid leave, which can either be for the employee's own health needs or to care for family members. What this legislation does is that it enables employers to keep their employees on the payroll while at the same time ensure that employees are not forced to choose between their paychecks and the public health measures needed to combat the coronavirus. This law takes effect on April 1st, 2020. As a side note, when the law first came out, it was supposed to take effect April 2nd, and the Department of Labor guidance changed that to April 1st. So April Fools, but in all seriousness, the law takes effect April 1st, 2020. The Families First Act consists of two main parts: the Emergency Paid Sick Leave and the Emergency Family Medical Leave Act. Very quickly, the Emergency Paid Sick Leave Act requires private employers with fewer than 500 employees and government employers to provide eligible employees 2 weeks of paid sick leave at the employer's regular rate to quarantine or to seek a diagnosis for preventative care for the coronavirus. It also requires payment at 2/3 of the employee's regular rate to care for a family member for those purposes, or to care for a child who is either out of school or whose child care provider is unavailable due to the coronavirus. And again, these provisions end in December 2020. For the EPSL, the Emergency Paid Sick Leave Act, all employees are eligible. They're eligible on day one of employment. There's no length of service requirement, no hours worked, none of those issues come into play. So part-time, full-time, seasonal, everyone's available. And you can take the EPSL leave for 6 reasons. And, on the next slide, we give you some homework that you can study for after class today with those 6 reasons and the amount of pay that you have to provide employees if they do go out on leave for one of those 6 reasons. So if you go out on leave for reasons 1 to 3, you have to pay the employee their regular rate, and that's capped at $511 per day or $5,100 in total. If you go out on leave for reasons 4 through 6, you have to pay the employee at 2/3 regular pay, and that's capped at $200 per day or $2,000 in total. The second part of the Families First Act is the EFMLA. That is the FMLA Plus. It provides eligible employees with 12 weeks of job protected leave. And there's only one reason, unlike the first part of the law, there's only one reason you can take this leave. It's to care for school and child it's to care for children who are home because their schools are closed due to the coronavirus. If you are unable to work or to telework because you have a son or daughter that's a minor who is home, you can take this type of leave at 2/3 of your pay. And again, that's capped at $200 per day and $10,000 total. Again, these provisions also expire at the end of 2020. Moving along, just quickly, there are reinstatement rights associated with the EFMLA. So this is job protected leave. If an employee goes out on this type of leave, they must return to work in the same or equivalent position. There is an exception here for employers with fewer than 25 employees. That's on the slide. And with that, we just want to mention the New York sick leave, which Tom will talk about.
So, yes, the New York sick leave is, I think we lost the slide somewhere, I don't know how. But anyway, New York sick leave is very limited. I get calls from clients. Does the new law say I have to give all employees sick leave? No, it doesn't actually. It applies to employees only who are subject to a mandatory or precautionary order of quarantine. And that doesn't mean what a lot of people are undergoing right now, meaning the governor says stay home. It means you or a family member with whom you reside have been ordered by the Department of Health to stay home, either mandatorily or on a precautionary basis. Hopefully you're not dealing with very many of those people, but I've gotten questions from clients who say, we're going to lay employees off. Does this mean I had to put them on sick leave instead of laying them off? And the answer, quite frankly, is no. There will be a mandatory sick leave New York State law that comes up later in the year. It's beyond the scope of today's discussion, but there is going to be mandatory sick leave starting at the beginning of next year. Topic for another day. These are the benefits that are available if you do have employees who are subject to this mandatory order of isolation or quarantine. And similar to the federal law that Haley described earlier, there are rights to be restored to the position after you take the leave. You have to be very cautious. Even if you say we've laid everybody off since then, we no longer have the business, we can't rehire this person. Talk to counsel before you make that decision. Save yourself the agita of a possible lawsuit. So that concludes our main presentation. We managed to get it done with 5 minutes to spare, and happy to field any questions in our remaining time.
So I'm looking at the questions that are being posed on the website. This is Dave again. And a lot of them have to do with some of the interpretations of the new statute, which is not even in play yet. And we're going to have to take a close look at those issues. So it's going to be hard for us to really answer some of those questions. I mean, the first question that I see in the queue really has to do with how does the AIA contract between owner and contractor handle this circumstance, because contractors are threatening clients with their losses. Well, I think that contractors are going to have a difficult time establishing losses in this current situation, because there are issues that are outside the owner's control. I'd have to look, as you could appreciate, the general conditions is a 35-page document. There are options of the owner to award a time extension. The owner could also terminate for convenience, but I'd really have to take a look at that issue in more detail, and I'm happy to answer that question offline once I review the contract. Tom, I don't know if you have access to the chats as well, because some of these questions have to do with the difference between laying off and terminating employees, although they may have been asked earlier on before you answered the questions.
Yeah, I did see that. There is really no difference. People say, what's the difference between a layoff and a termination and a furlough? The answer is not very much. The employee stops getting paid, and a furlough, again, it has no real legal significance, and a termination is just a general word for ending somebody's employment. A furlough, it sounds nice if you tell an employee we're furloughing you as opposed to laying you off, because there seems to be an implicit promise, or at least a hope, that when this crisis is abated, we will call you back to work from the furlough. But frankly, an employee can be laid off while on furlough also and be told, sorry, we're not going to be calling you back. The employee is entitled to collect unemployment benefits in either case. Somebody asked how will I know if somebody's been quarantined by DOH? There should be some sort of order, yes. You don't just have to take the employee's word for it. And in fact, if an employee has reported positive and informed you of that, you're supposed to inform DOH yourself that you have an employee who tested positive, and DOH will guide you into the appropriate steps, possibly to clean the workplace and to inform fellow coworkers and clients or customers.
Tom, there was a question. Can you explain what exempt employees are?
Yeah, I think I did in my previous comments. Executive, administrative, or professional employees who earn more than the minimum salary required by New York State. And they're people who are paid on a salary, which means they're not paid on an hourly basis. Anybody paid on an hourly basis is not exempt, period. And non-exempt people are entitled to overtime if they work more than 40 hours, whereas exempt people aren't entitled to overtime.
I noticed that a lot of the questions are dealing with the issue of essential versus non-essential. And I can tell you, because I get a lot of my clients call me, and we actually, as a law firm, reached out to the New York State Empire Development Corp for clarification, because they're the entity that, if you're not sure, you're supposed to ask them. So we wrote them and said, hey, we're as a law firm, we support consultants who are supporting construction, and we felt there was a reasonable argument to be made that we represented an essential practice. What I got back was a vague response from the Development Corp saying, well, I would refer you back to the information in the order. Then I actually made a phone call, and the person who answered the phone, her dog was barking in the background. And the only significance I attach to that, because I'm not making fun of her at all, is that she's working from home also, trying to interpret the same order that I was. I do see someone very early on indicate in the question and answer stream indicated that Cuomo just announced that construction is not essential. So, to be honest, I haven't heard that announcement, but I'm interested in it, and I'm gonna when we stop after the presentation, I'm gonna check that out. It's really going to be impossible for us to answer all of the questions because a lot of you have a lot of them. Some of them are really related to the new legislation, which the three of us are going to be reviewing as we go forward. What I would suggest is that you have our email addresses, and you can issue questions directly. I would say on the labor and employment, I would probably refer directly to Tom and Haley, but you can copy all of us on them, and we will do everything we can to try to respond to your questions. And if we don't know the answer right away, we're still going to be checking out these issues, and we can circle back with you. So, and the only reason I'm sort of suggesting that is because it's 11:59. We covered a lot of material, and I'm guessing that at 12 o'clock we're all going to turn into pumpkins, and the presentation is going to be over. So, with that, I'd really like to thank everybody for participating and joining us on this call. And I do encourage you to reach out to us directly because we're happy to continue to try to answer your questions. These are really important issues during really difficult times. And if there's anything that we can do to support your practice, we're happy to do so. Paul, is there anything else that you need from us as it's 12 o'clock now?
No, the presentation has been absolutely terrific. Thank you.
Very good. Well, thank you all, and have a great day.